These parties spent several months attempting reconciliation, which is part of the reason why this case has been on file for as long as it has. This morning, Ms. Locke and I discussed scheduling a structured settlement. The parties have exchanged settlement offers. They do not agree on them, obviously. Otherwise, we'd be here to put a final divorce decree on the record. But they are much closer than they have been. But there were several months where they worked on reconciling, which I think it's important for the court to know that they had attempted to not proceed, and that failed. But that caused quite a significant pause in the case as well. And then I do want to put on the court's radar that there is a procedural issue that I need to raise if we're going to proceed on this contempt.
We are going to proceed on this contempt. Ms. Levitt, what is the procedural issue that you raise?
Your Honor, for when a contempt is filed, it is required by statute KSA 20-1204A subsection B that the order to appear and show cause shall be served upon the party allegedly in contempt by the sheriff or some other person appointed by the court for such purpose. In this case, this contempt was not served on my client by the sheriff or a process server. The return of service shows that it was mailed to my client using certified mail, which is not allowed for under the statute. So although my client is here and present, it's due to the other motion that was filed. The service is not correct on the contempt, and the statute is clear. It says shall be served by a sheriff or process server.
What other motion are you referring to?
Your Honor, Ms. Locke had filed a motion as to some discovery issues. There was a motion to compel and a request for inspection.
So your appearance, your client's appearance on the contempt is a special appearance to challenge jurisdiction.
Yes, Your Honor. The statute is very clear as to how service has to be done, and it was not complied with.
Ms. Locke, I believe that is a requirement in this case. Why wasn't this served by the sheriff?
The judge wastes no time pointing out this divorce wasn't quick. Why? Because the couple actually tried reconciliation. That adds months of delay, an emotional weight. Imagine fighting through counseling, only to end up right back in court. Do you think reconciliation attempts help, or just drag out the inevitable?
Your Honor, if it was not served by the sheriff, that is an error on my part. My understanding is that it was sent for sheriff service, but if it was not, that I agree is an issue.
It's an issue that precludes the court from going forward with the contempt citation at this time. The court finds that there was improper service in this case, that the court does not have authority to go forward on the contempt citation at this time. With that said, there are some serious issues raised by this contempt citation, and I would sure hope that the parties in this case would recognize the privacy rights of the other. Nevertheless, the court will make no contempt finding at this time, and we'll move on to what appears to be the other motion before the court, and that apparently deals with discovery issues. Ms. Locke, you may proceed further in regards to that.
Thank you, Your Honor. We have, as I stated to the court earlier, and just for a little bit of clarification on Ms. Levitt's position, my client disagrees with the idea that the parties were attempting to reconcile. She has not been interested in reconciling, and has made that very clear to the petitioner in this case throughout the case. However, we've issued discovery twice in this case, as well as a request for inspection. I cited in my motion that we didn't have the petitioner's tax returns. That issue has been resolved. I also had concerns about cryptocurrency. That issue has not been resolved. There was a statement to us that the cryptocurrency has since been sold. However, we have no affirmative documents related to the cryptocurrency. The petitioner has been played some sleight of hand with the cryptocurrency, says he has documents but doesn't have documents, says we could get them but he can't get them. So we have challenges with that. He is very tech savvy. We would like the documents related to the cryptocurrency to value them as a marital asset. Additionally, the parties have some pretty significant toy collections, an RC car collection, which I believe has been agreed upon, but also a Lego collection. We asked and submitted a request for inspection related to the Lego collection. There was no response ever provided related to our request for inspection. And so that is part of our motion to compel here today to allow us to get the Lego collection inspected and valued as a marital asset.
Here's where it gets technical, but crucial. A contempt notice must be served by a sheriff or court-appointed officer, not just mailed. Why? Because contempt can land you in jail. The wrong service method means the judge's hands are tied. Small detail, massive consequence.
All right, Ms. Levitt.
Thank you, Judge.
Your response?
Yes, Judge. And I know that this is not the issue, but I just do want to tell the court on the reconciliation. These parties went to marriage counseling for weeks. So that wasn't for reconciliation, then I guess that is what it is, but that's why my client believed they were working on reconciliation. As to the discovery issues, the cryptocurrency that my client owned is called Ethereum. It is held through a Robinhood account. I am looking at an email that was sent with all the discovery responses as digital attachments to Miss Locke, in which the Robinhood account that holds the Ethereum, $600 worth of cryptocurrency, was sent as part of discovery responses. We have responded in a follow-up letter that Ethereum is cryptocurrency. It is held in the Robinhood account. That is what Robinhood is. It's like E-Trade is for stocks, Robinhood is for cryptocurrency, and that is all the cryptocurrency that my client is in possession of. The way Robinhood does their statements, Judge, is you are advised that you can have a statement available for download each month. If you go in and download it, then you have the statement. If you don't download it for that month, you cannot go back to prior months to download it. So I've advised that Miss Locke, she can send a business record subpoena to Robinhood and see what she can get. My client had statements from when he had opened the Robinhood account, and then he had a statement from the month when discovery was received.
And just like that, the contempt case collapses, not because of evidence, not because of guilt, but because of a paperwork slip. This shows how in court, process is power. Do you think that's fair justice or just a loophole?
That is all the cryptocurrency he owns. They have repeatedly asked about him owning Bitcoin. We have answered that he does not own Bitcoin. He's never owned Bitcoin. Quite frankly, I think that this is an attempt by the respondent to allege that my client is hiding this money that doesn't exist. And they want us to prove something that you can't prove a negative. I can't prove that there is no more cryptocurrency than the Robinhood account. We have handed over the Robinhood account. As to the request for inspection, a Lego list with all of the all of their sets they put out, Judge, have like numbers. They put serial numbers on them. So a list with all the serial numbers, the name of the Lego set, the value of it off of the lego.com website and off of ebay.com for older sites has been sent to Miss Locke. I advise that if she had someone who was able to value a toy collection or a collectibles like Legos, that we could make the items available for inspection. But if it's merely the respondent wishing to come into the marital residence and dig through my client's Lego collection, these parties were married for a very long time. She bought many of the items and gifted them to my client over the years for birthdays, Christmas, those things. She has been at the house 3 times by agreement to pick up property and to go through the party's personal property and divide it. She's been at the house several other times, entering the garage without consent to go through personal property and take items. She has had plenty of opportunity to view these items, besides the fact that she, throughout the marriage, was one of the people who helped my client receive those items as part of his collection. We do not oppose an inspection, but I'm not sure what the respondent's ability to value that collection is if she sees them themselves versus receiving the list of the items. And I think that if we're calling this a collection, if there is some issue or concern by the respondent that these are collectibles worth more money than what they were purchased for. For example, if you were to talk about somebody who collects like rare baseball cards, then the respondent is not qualified to make an assertion of that value. It would require somebody who runs like a comic book store, somebody who's within that collecting world, who as part of their profession values those collectibles, to say this is the value of the item. The respondent herself would not have the prerequisite knowledge to do that. And so quite frankly, I don't know what information they're seeking other than they say they want to know about the toy collection. Well, they know about the toy collection. They know it's Legos and RC cars. They have an entire list of all the serial numbers. If they believe they're valuable collectibles, which they are not, Judge, I do want to be clear on that. My client is a big fan of Star Wars and he likes Legos. And so he's purchased a lot of the Lego Star Wars sets. He's been gifted a lot of the Lego Star Wars sets. They average about $29.99 a set. They are not rare collectibles. They're not hard to find. They're all over eBay, which is why the list was created as to what their value was. But if she believes that they are worth more than what they are sold for online, then she needs someone who is an expert in that world to make that determination, not her.
Ms. Locke, do you have a valuation expert in mind to inspect these toys and to give a fair estimate regarding their value?
Your Honor, our request for inspection specifically states that we be allowed to come in to picture the collections so that they can be valued by an expert in the field. So we have not secured an expert, and obviously we would be required to do disclosures for that, but the purpose was not for us to come in and my client decide what the values are. The request for inspection specifically asks that we be allowed to photograph the Lego collection so that we can then go and have it be valued. Additionally, Your Honor,
can an expert do it purely from photographs without being able to see the items themselves and their current condition?
Your Honor, I think that would be at least a good starting point for us. Again, I just want to give a little bit of backstory here. We issued discovery in 2024. We issued a second set of discovery early in 2025. We had to file a motion to compel to get responses to our second set of discovery. Ms. Levitt talks about this list that she provided us of all of these Legos. I got that list at 4 o'clock on Friday. Today's Monday at 10 a.m. So the idea that we've had all of this information and we could have done all of this stuff is just not accurate. I received her document at 4 o'clock on Friday for this hearing at 10 o'clock today, when the request for inspection was in early May. And so there was plenty of time to respond and say, hey, here's the list. What more information do you need? But instead, we're getting this information as a result of us having to file a motion, which is improper. The discovery in these items should be forthcoming. And it should be, Mr. Roberts is not qualified to value a Lego collection in the same way that my client is not qualified to value a Lego collection. So we thought starting with the easiest, most low cost option would be viable to let us come in. Again, we specifically requested the opportunity to come to the house rather than just showing up at the house, to come in, photograph the Lego collection, and then try to have it valued. And I think that request was completely reasonable.
Well, if you're going to submit the pictures to a valuation expert, presumably, to determine value, why can't the valuation expert be on site to actually view the items and make a determination that way? I realize that might be a little bit more costly of an option because it would involve more of the expert's time. But I guess I failed to see what value your client taking pictures of these items would have if there's a concession that neither party is in a position to value them.
Your Honor, we would be happy to coordinate an expert to come in. But again, these are items that could have been resolved between counsel had a response been filed to our request for inspection. There was never even an objection to our request. They just simply never responded to our request to be allowed to come in. If Ms. Levitt would have said, you can't come in the time frame that you presented unless you have an expert, I would have said, okay, let us get someone on board and we can schedule a time that individual, my client and myself, will come to the house to do the inspection. But those responses are not forthcoming from the petitioner who filed this case and should be the one that is pursuing it. And so these are the challenges that we have faced at almost every set of discovery.
Well, there may be some considerable value in these toy collections.